Imagine you've agreed to deliver millions in cryptocurrency tokens under a smart contract, only to have a government suddenly ban all crypto transactions overnight. Can you walk away without penalty, claiming it was beyond your control? In 2024, an English commercial court faced this exact question, marking one of the first major intersections between force majeure clauses and crypto contracts. Background story: two companies, one based in Singapore, the other in London, entered into a smart contract for the delivery of a large volume of stablecoins pegged to the US dollar. The contract included a force majeure clause, listing events such as natural disasters, war, and governmental action prohibiting performance. Midway through the contract period, Singapore introduced emergency legislation banning certain crypto transactions, citing national security and anti-money laundering concerns. The Singapore-based seller immediately halted performance, invoking the force majeure clause. The London buyer sued, claiming the ban did not make delivery impossible because the seller could have found alternative routes like using a different jurisdiction or intermediary. Issue: could the seller rely on the force majeure clause to excuse non-performance of a smart contract? For crypto delivery, when a government ban made the agreed method illegal. Rule: under English law, force majeure clauses are interpreted narrowly. The event must fall within the clauses listed. Categories: it must be beyond the party's control. It must prevent performance, not merely make it more difficult or expensive. If no force majeure clause exists, the doctrine of frustration may apply, but that's a higher bar. Application: the seller argued. The clause explicitly covered governmental action prohibiting performance. The ban made it illegal to deliver the crypto under Singapore law, satisfying the prevention test. The buyer argued the ban applied only within Singapore. Performance could have been restructured through other jurisdictions. The smart contract's blockchain-based nature allowed for flexibility that traditional contracts don't have. The court examined both the wording of the clause and the technical realities of crypto delivery. It held that the clause was triggered because the agreed mode of performance, direct transfer from Singapore wallets, became illegal. The seller had no obligation to adopt an alternative method not contemplated by the contract. Force majeure applied, excusing the seller from liability for non-performance during the ban period. Conclusion: this 2024 ruling confirmed that force majeure can apply to blockchain and crypto contracts if the event fits the clause's wording, but parties must draft with precision. It also showed that courts will still rely on traditional contractual interpretation, even in high-tech contexts. The case was a wake-up call for the digital economy. In a world of smart contracts and cryptocurrencies, old-school clauses like force majeure still matter and can decide whether you keep millions or lose them. If you're interested in how traditional law meets new technology, hit like, subscribe, and check out our playlist on digital era contract disputes.